marital rape exception takes away, it is argued, takes away that bodily autonomy of a married woman. And this is a law which unfairly discriminates the married women vis-a-vis the unmarried. It would be very difficult for a husband to establish that he did not, in fact, rape, or that it was given on account of a consent.
Can a husband rape his wife and not be charged? Hello and welcome to the New Indian Express. This question has been plaguing the Supreme Court for the past few weeks. Hearing after hearing, but still no answers. Now the latest hearing has been postponed to after Chief Justice Chandrachud's tenure. The Supreme Court has admitted that this case requires a lot of contemplation. What is so complicated about this case? What are the rights of a wife that are being violated by not making marital rape a criminal offence? Why has marital rape been kept out of the purview of the justice system till now? To answer these questions, we have with us legal expert Nipun Saxena. Watch this video to find out more about this case and its various issues.
Thank you, Alan. Thank you so much for having me.
Okay, I'll get down to the most important question. Why is marital rape not being seen with the same gravity or with the same grave nature as we see rape?
Well, one of the reasons is because there is a specific incorporation in section 375 of the IPC itself. And there is an explanation number 2 which has been attached to it, right? Which says that a man is not said to have committed rape on his wife if that wife is a woman who is above 15 years of age. So a rape with a woman who is wife of the husband who is above 15 years of age will not be considered as rape. And this is what you popularly call the marital rape exception, right? And one of the reasons that why it is a subject matter of fierce debate is that both sides, one side which is in the favor of removal of this exception says that, look, it essentially creates two different categories of women, one being unmarried women vis-a-vis married women. And this is a law which unfairly discriminates the married women vis-a-vis the unmarried women. Right? And therefore, you know that it's a clear case of manifest arbitrariness, as they like to call it, because it's a violation of Article 14. You cannot have differential treatment of law. The law has to equally apply to everyone, right? And therefore, they are arguing that this would be a violation of 41 as well as Article 21, because Article 14 says equality and Article 21 says protects dignity of an individual. And they say that this particular provision is an affront to the dignity of all married women. And therefore, they have mounted a challenge. Now, those that are in favor of retaining this provision essentially make a couple of submissions. The first of which is that they say that, look, Parliament has had 4 opportunities. They had an opportunity way long back when this particular provision was engrafted. Then they had opportunity sometime in the 1970s. There were criminal law reforms which have been introduced from time to time, Justice Malamat Committee's report, as well as the recent one, which was Justice Verma Committee's report of 2013, right? And to eliminate all of those things, even the latest 3 criminal laws that have come in, right? The BNS, the Bharatiya Nyaya Sanhita, it also prescribes for and retains this marital exception. So what they are essentially trying to say is that, look, when the Parliament in its wisdom has decided to retain this particular provision, then what is the sense to, it basically shows that this is the greatest example of the parliamentary intention in favor of retention of a provision. Now, the question really is that, of course, I mean, the other side would want to argue that merely because the Parliament has decided to retain it does not mean that it does not take away fundamental rights. And if it does take away fundamental rights, then it would be void under Article 13, subclause 2 of the Constitution, right? So those are the challenges and counter challenges that are being mounted. One of the other propositions in favor is essentially that this particular marital rape exception would suffer the same fate of low conviction rape as have been other provisions like 498A, etc., etc. Though I don't think that's a very strong ground to argue, but these are some of those grounds that have been taken, that So those are essentially, which is why this has been a subject matter of intense debate. You already know that the Delhi High Court had passed a judgment, right, in which even the two learned judges had expressed divergent views, right, and therefore the matter has traveled to the Supreme Court to finally decide either in favor of retention of this exception or of its removal.
Now, one of the most explicit violations of the articles is the Article 14 violation, the right to equality, because a married woman, a marital rape is not being seen as the same with the same lens as rape is being seen. But the petitioners have also argued that this is a violation of the right to privacy of the wife in the relationship. Could you express your views on that?
See, one of the facets of right to privacy is also right to autonomy of an individual. As long back as in Khadak Singh's case, the Supreme Court had said that right to privacy essentially means that the home of a man, in that context, of course, now it applies to home of a person, is that person's castle, right? That same principle has now been superimposed to also talk about one's bodily autonomy. Marital rape exception takes away, it is argued, takes away that bodily autonomy of a married woman and sort of denudes her of her agency of her own body to decide whether she wants to have a consensual sexual relationship with a man who she is married to, or on some occasions, even if that sexual intercourse is non consensual in nature, does that mean that her autonomy is taken away? Therefore, this also becomes an argument, as you rightly said, one which is premised on the right to privacy. The right to privacy essentially means a right of a person to assert their own bodily autonomy.
Yes, most definitely. But one thing that the defendants actually argue about this is that this will act that the evidence collection is a huge hurdle, that if marital rape becomes a crime, evidence collection will be a huge headache. And in a lot of divorce cases, this section will be brought in. So basically what they're trying to say, there are a lot of headaches that come with this. Though it is unconstitutional, it requires a lot of preparation. The judgment requires a lot of thought before it comes to. What do you have to say about these headaches, these technical headaches, as we can call them?
See, I wouldn't, any criminal law practitioner will not just dismiss them as merely technical. You see, what happens is when a rape case is registered, and I'm talking about a rape case where the people are not related in marriage. Right? In such a case, there are provisions under the Evidence Act which kick in, which essentially casts a reverse burden of proof on the assailant, on the aggressor, to establish how that person is innocent. Right? So it is not innocent until proven guilty. It is you are deemed to be guilty until you establish how you are innocent. So in that unique aspect, rape, terror-related laws, money laundering laws are all same. That's a distinct category, which casts what you call a reverse burden of proof. Now, if you were to employ the same reverse burden of proof vis-a-vis a husband, let me first tell you what that reverse, how does this operate? How does this function in court? It essentially functions like this. I am a woman, and if I go before a court, I take a stand, or I even give my 164 statement to a magistrate, and I say that, look, I have been raped and X is a person who has raped, then it shall be presumed that the factum of rape stands proved unless and until the other side can rebut it. There is a standing presumption in my favor. And B, that X is the aggressor. Now it is for X to establish how he has not raped. Now, in an ideal scenario, that makes perfect
I'm
sense.
just so sorry to interrupt you. I just felt like I should be saying this. One of the places where I read it, the person who was advocating it, he bluntly said that, do we actually have to put cameras in our bedroom to make sure for the evidence? Well, he was so blunt about it. So to talk about the intensity of this headache of evidence collection in this case.
See, now, why I'm using this is because of 114A of the evidence. And like saying, I'm not on evidence collection. I take it that there is something which is available on both sides to demonstrate their respective cases. I'm here when everything is collected. What happens then? Now, there's a standard reverse burden of proof which operates here. If a man happens to be a husband, he can't deny that there's no sexual interaction or that has taken place. Would it be fair to place a husband on the same pedestal as any other person? Uh, if a woman alleges that she has been raped, then immediately 114A gets attracted. And it will be very difficult. What those in favor of retention of this provision are arguing is it would be very difficult for a husband to establish that he did not, in fact, rape, or that it was given on account of a consent. Because the manner in which consent operates under section 375 of the IPC was that it shall be presumed if a woman says that she never gave a consent, that she did in fact never give her consent. Now, if it is any other person other than the husband, it is, then the complainant statement has to be taken on the face value. And it is for the other side to establish by leading evidence that that person has not committed. But would it be fair to apply the same reverse burden of proof vis-a-vis a husband? That's the $1 million question that the court has to respond. Right. Second, what is also being argued is that insofar as rape is concerned, it is also a form of assault. Right. It is a physical assault. It's an act of physical cruelty for which a person, a spouse, can also claim a divorce from the other spouse. So it is not that the person is left remediless. That still becomes a ground for divorce. In addition to, of course, 498A can be made applicable. Grievous, hurt, etc., voluntary causing hurt, etc., are also other provisions that can be made applicable to such a case. So those in the favor of retention of this provision are also arguing that there are ample redressal mechanisms available in law to the woman who is a married woman. And therefore, there is no necessity to remove this exception. It is not that the married woman is left remediless. If she wants, she can take divorce. If she wants, she can register n number of cases against the person. But why rape? Right? Because rape but of course, the other side, those who want this particular provision to be removed, would then argue that a sexual assault is a sexual assault. It does not matter whether the person committing the sexual assault happens to be a stranger or a husband. You cannot have two differential treatments when you can't have two differential treatments when it comes to the the survivor of the incident. Then you cannot have two differential standards for the aggressor. And it does not matter whether the person who is the aggressor is a stranger or a relative or a husband. The law must apply equally. Now, under the Evidence Act, there is another problem that there is what you call spousal immunity, which is attractive, right? That a man and a woman or a husband and a wife, unless litigating against each other, are not competent witnesses. Now, in this case, they will be going at loggerheads with each other. One party trying to establish that he was not there or he did not rape. And the second party, of course, asserting that she was in fact raped by this person. Right? So how do you see there are very structural issues which have to be addressed. The answer is not that easy.
Okay, thank you, Nipun. Thank you for talking to us in such great length about this matter. As of right now, we just got the news that the judgment will have to wait for a long time. It might even go further than the Chief Justice of India, D.Y. Chandrachud's tenure. So we'll just have to wait and watch as to what actually happens. When will this judgment come? We'll just have to wait and watch. Thank you, Nipun.
You're welcome. You're welcome, Alan. It's always a pleasure interacting.
Yes, Nipun.